and we are glad that everybody's here, and we have an hour for this. And one thing is certain, which is that trying to teach Immigration 101 in an hour will be a true challenge. So with that, I wanted to introduce myself. I'm April Land. I'm lucky to teach here at the University of New Mexico School of Law. I'm also very fortunate to be part of the Bleefer Border Justice Initiative, which is bringing you this CLE, which we hope to be part of a series. We thank our Dean and Vice Dean, Academic Dean, Camille Carey for supporting this, Sue Georgian and Cheryl Beerbank for putting this together, as well as the leadership team and everyone who is attending. There are a couple of quick things I wanted to cover first. We are recording this, so we should be able to make that available also for people who weren't able to attend. If you hear of any, this should be available for self-study. We have been asked to ask you to all turn your sound off so that there won't be any distractions. And then to get your CLE credit, you will need to complete a form. If you haven't received your form from Cheryl Burbank, she asked that you let her know or let us know, and we will send you that form. There is a lot of material to cover, so Professor Kitson will be taking questions by chat, and we'll be monitoring the chat. And before I turn this over to Professor Kitson, to whom we are deeply grateful, as well as hopefully Jesse Miles, who will hopefully be following up with the second part of this series, of this 5 to 6 part series on Fridays at noon that will continue on July 10th. But really what we're trying to do is help educate people, help connect people with each other and with this community in the hopes of being able to bring services and high quality legal services to people who are suffering at the border. So please, at the end, there will be a way for you to contact us to let us know if you'd like to volunteer. And we hope to be able to create volunteer opportunities for people of all different levels of skill and interest. So let's thank you again, Professor Kitson, for agreeing to do this. Thank you all for attending, and I hope that we can be part of increasing the legal services, if not just the awareness for people who are trying to immigrate. So with that, I hand it to Becca. Thank you.
Hello, everybody. I always say I've got my air traffic controller thing on here to keep hopefully the background noise down. Although crazy things happen on Zoom, as I think we all know at this point. I am going to go ahead and share my screen. And I should be able to, here we go. Start from the beginning. Okay, so I am going to fly through, as one of my colleagues just said, bending the space-time continuum to be able to make it through all this material. Like we said, you can ask questions in the chat if you want. There's some slides that I'm just going to rip through quickly because they have, I have some graphics and that sort of thing, that charts that you'll be able to look at later too. I get a lot of my information, of course, from the Pew Center, because they have great statistics on immigrants, as well as from the Cato Institute, which also has good information. So I am going to do a whirlwind tour of immigration law. I know that though people are going to be approaching this from, you know, from different backgrounds. I know that I've seen at least some of my previous students here, so I know that they've already been through my style of teaching already. But I'm going to try and touch on the major parts of immigration law and kind of give an overall picture. So the good place to start always is, who are the agency players? In immigration law, as we know, there's multiple different parts of the federal government that are involved in immigration. And there is also part of the challenge of practicing immigration law is that it's all over the place. Even in just trying to get basic documents in order to be able to move forward with a case, we have to file Freedom of Information Act requests with multiple different locations. The primary ones are the ones that are listed here. DHS for affirmative stuff and inside the country, Department of State for outside of the country, and Department of Justice for the immigration court system, and then the Department of Labor with a lot of our employment-based immigration. Here's a very non-exhaustive list of immigration statuses. I use LPR or green card holder to describe, lawful permanent residents, those who have the permission to live and work in the US. And, there's multiple other types of status. There are also tons of kind of quasi status within immigration law where somebody may or may not be, in unlawful status or undocumented. They might still have a work permit. So there's a lot of spaces kind of in between the regular established types of statuses as well. Immigration law is very different than other areas of the law because while it looks criminal, and I think that a lot of times the way that it's described to people is in criminal terms, it's civil. So it does not trigger the same type of constitutional protections as we see in the criminal context. I think it's confused by the fact that there are immigration-related crimes, but they're separate from the actual immigration system itself. I know, like many of you, have probably engaged in way too many Facebook discussions / arguments about, the term illegal or using that sort of term within the immigration context. It's not something that I typically do because it's not only offensive, but it's also legally incorrect because you're really dealing with civil law. Deportation is considered to be a legal sanction, but I mean, it does not consider to be a legal sanction or a punishment. It's supposed to affect the removal of somebody from the United States, even though, as we'll discuss a little bit, civil detention looks a lot like criminal detention because they're often in shared criminal facilities. And there's no right to unpaid counsel in removal proceedings. So it's a statutory right to counsel versus a constitutional one, as you see in criminal proceedings. And so while immigration law, again, smacks of kind of our criminal system, the protections that are allowed simply don't exist within immigration law. All right, so just a little bit of background on our immigration population here in the US. You can see this with this slide, it goes from 1960 to 2017, just that the composition of immigrants has shifted significantly. And that Mexico is actually on the decline for being a generator of immigrants to the United States. That an interesting fact is that unauthorized immigrants are only a quarter of the US foreign-born population. It's interesting because you would think from, especially listening to, the media or other discussions, that it's dominated by unauthorized immigrants, but that's actually not true. They are a limited percentage and less than a quarter. This slide to me is really, really fascinating in the sense that only 40, at least as of 2015, and I would argue it's probably even less now, only 45% of the US population knows that fact, that we're only talking about 23% of the foreign-born population that is undocumented. So out of the 34 million lawful immigrants residing in the US, most people believe that it's most people have the wrong impression of the composition of the unauthorized and authorized immigrants living in the US, which of course leads to crazy discussions because we don't even know what we're talking about half the time when we're talking about immigration. This is also an important fact in describing, the people that I represent and love, that when you're speaking about unauthorized immigrants in the US, those who don't have papers, that the typical unauthorized immigrant has lived in the US for nearly 15 years. So, again, contrary to some of the things that you hear sometimes, folks who have entered the US and given increasing enforcement and shifts in the law and additional sanctions for people, most people who have entered remain here for a significant period of time. And in fact, we're talking about over 2/3 of the unauthorized population has been here for over 10 years. Even given all of that, the numbers have actually been on the decline for some time, and continue to drop from the latest statistics. The number one group in decline is Mexican immigrants to the US. Okay, so I always have to do a quick mention of immigrants and crime, because the two so often are tied together. Um, this is, I have a couple of statistics that these are recent studies that have come out, and the incarceration rates by immigration statuses from 18 to 54 years of age. You can see that the native-born population is double that of people who don't have status in the U.S. And legal immigrants is about half then again of that. This was a study done by the Cato Institute, which of course is a libertarian-leaning institute, and they did an extensive study of criminal conviction rates in Texas. And again, you can see the same trends moving across native-born, undocumented, and legal immigrants. I think that another very powerful image, of course, is that also from well accomplished studies, they do demonstrate that the larger number of the undocumented share of your population, the less violent crime you actually have in your community. These are all data points. Obviously there's outliers, but the trend is pretty clear overall, that the more undocumented people that you have in your community, the safer that you are. So moving on to ways to actually obtain status in the US. It's interesting because I've had people ask me as an immigration practitioner, what do you do? How is it even possible to help people? And I'm like, wow, there's this whole entire world out here, different ways to come to the US lawfully. And, ideally, and when you're successful, you're able to get somebody either temporary or permanent status within the US. So as I mentioned at the beginning, there are temporary, permanent, and then these sort of purgatory statuses, as I like to think of them, that are in between, like the Deferred Action for Childhood Arrivals, the DACA program, which has been very much in the news as of late with the new Supreme Court decision coming down, is really a type of quasi-status. Deferred action is in that category. So there's two very distinct ways that people gain status in the US. And I think that this is particularly relevant given the president's proclamation of this week. And I've got some slides at the end where I'm going to go over some of the recent changes. And I think that, after reviewing some of the basics of immigration, it really comes into light, and you can kind of see where it fits within everything. Their visas are documents that are issued only at U.S. consulates abroad. So visas are generally permission to come to the United States and knock at the door. They do not allow for entry necessarily to the United States, because the Border Patrol ultimately will determine the length of stay and whether or not somebody is allowed into the country. But if you're outside of the country, generally people will process status through the U.S. consulates abroad. Historically speaking, the executive branch has had greater power over people who are outside of the country through foreign affairs power, through the interaction with the rest of the world, national security. All of those things are kind of brought to light with the power over the U.S. consulates abroad. And it's also something that was reiterated in the Trump v. Hawaii case with the U.S. Supreme Court as it pertained to the travel ban, the different successive travel bans. Inside the United States, it's currently the Department of Homeland Security and its sub-agencies that generally work through those types of status. When we talk about status inside the country, it's status versus visa. There are those that given U.S. law, that are required to leave the country. If you're not eligible to obtain status inside the country, there's times where the law requires that you depart, that you leave and actually process through a U.S. consulate to return in the proper manner. So temporary visas are generally what we call non-immigrant visas. And a non-immigrant is a non-citizen who seeks entry to the U.S. For a specific purpose. So the way I describe our immigration system a lot of times is that if somebody wants to come here, that the default answer is no. And then there are exceptions. There are pigeonholes within our immigration system that allow for people to come in for specific reasons. That goes for the non-immigrant visa side of things, which are temporary, and for the permanent residency side of things. In general, the sense of things, and I think my colleagues would probably support me in this, is that our general immigration system is set up as one of defense. Like I said, the default answer is no, and then there are exceptions to that. So there's a whole laundry list of non-immigrant visas. They all have letters, so it's what we like to call alphabet soup. There are times, every single one of these non-immigrant visas has specific requirements and limits, requirements, and then also additional benefits as to who can come with them. If derivatives, as we call them, those are adjacent family members that are able to piggyback on the petitions, whether or not they can come with, who's authorized to work, if they are, under what circumstances. It's all depending on which category you fall in. So here's some of the alphabet soup. We have employment-based visas, a whole different variety of those. Some of the letters that you see here, I is for international journalists, L's are for intercompany transferees, O's are for extraordinary ability workers. I think of them as outstanding because of the O. P is generally for performers, R religious workers. So you can see how the visa itself is tied to the purpose that they serve inside the United States. We have different types of student visas, of course. Treaty visas, the TN visas, it's what we call a NAFTA visa. It allows for professionals to move between Mexico, Canada, and the US, but it's only for those nationals. E-visas are for treaty trader visas, so they have to do with investment or in moving goods back and forth between the US and other countries. K visas are the fiancé visas. The stuff of TLC, I guess. They are a sort of a hybrid visa, really, because that visa has the intention of immigrating to the US. Law enforcement visas, the ST and the U, these are ones that we see very commonly. U's are for victims of violent crime, T's are for victims of human trafficking, and the S visa, the elusive unicorn S visa, is colloquially known as the snitch visa. It's for federal witnesses, but the average number of those visas that are granted every year tends to be less than a dozen. So I've seen one in 13 years of practice, one person who actually had an S visa, and I almost fell off my chair. So H-1Bs, H-1Bs are a garden variety professional visa. So these are the ones for specialty occupations. Most professional students who come to the U.S. or who go on to college that are graduating with whatever level of degree, they're allowed for 1 year of what's called OPT, Occupation and Professional Training, after their graduation and after they obtain their degree. Most of those folks, if they want to stay in the United States, remain and work, will try and apply for an H-1B visa. The problem with this is that there's a cap. There is a quota of 65,000 per year, and then there's an additional 20,000 for those who obtain their master's degree inside the U.S. Throughout the years, there's been a lottery, especially since the last recession. There's been a lottery for these types of these numbers and these types of status in the US. As you can see, the last fiscal year, we just completed the lottery. Applications were accepted as of April 1st. It's usually filled within a space of like the few days that they have open, and that's for an October 1st start date. So it requires a lot of planning in order to be able to at least get in the lottery. As you can see, I was joking, you go to law school because you can't do math, but for some of us anyway. But for the 85,000 visas that are available, we had 275,000 applicants last year. The numbers for these visas have not changed since 1994, I believe. And so they've been the same for an incredibly long period of time, and they have not been readjusted. As far as temporary humanitarian relief, I mean, we're still seeing renewals of DACA. We don't really know at this point what the Supreme Court's decision means as far as initial applications. I think most people would agree that the decision that came down just recently basically rescinded the rescission of DACA because it wasn't properly it didn't follow APA requirements in September of 2017 when the Trump administration attempted to phase out DACA. So that was the essence of the Supreme Court decision. There technically should be initial applications accepted at this point, but from what we can tell, USCIS and the agency, the only thing that they did was put out and basically an angry statement that used the term illegal alien, and you can see it for yourself at the USCIS website, but they've put nothing in place in order to accept those new applications, although there are some of us that are already starting to send them in. So we'll see how that plays out between the Department of Homeland Security and USCIS versus the Supreme Court. As I said before, U's and T's are very common visas that we see within the humanitarian context as well. All right. Rocking along here in our whirlwind tour of the Immigration and Nationality Act. So there's 5 ways to a green card, and 5 principal ways. I get a lot of people who call my office and who want to obtain residency, and a lot of times I'll have people who start listing off their all of their wonderful attributes. I can do this, I've done this, I'm a good person, I've worked really hard, I have great things to bring to the table. And I think that the assumption a lot of times, not only from foreign nationals themselves, but even from people in the United States, the kind of pull yourself up by your bootstraps kind of mentality is that if you are excellent enough, that the path will be laid before you. And that's simply not true in our immigration system. Again, the answer is no, with these exceptions. It's not an individualized analysis, it's whether or not you can fit into the category. So out of the categories that we do have, the bulk of our green cards come from family-sponsored immigrants in any particular year. These statistics are not super recent. I believe they're from 2017. So the number of refugees has dropped down significantly as well, because this administration has also practically eliminated the number of refugees coming to the US. So that slice of the pie is now even more greatly limited than it was before. Family immigration, the sort of purpose behind the law is family unity. And it has to do with being able to immigrate to join somebody in the United States who has status. So for family-based immigration, the one sort of subset of family-based immigration that's not subject to quotas is the immediate relatives. So those are the spouse of a United States citizen, an unmarried child under 21 years of age of a US citizen, or the parent of a US citizen child who's over 21 years of age. And I'm talking about the ways to qualify for something. I don't have a bunch of slides on the ways that you can be blocked from obtaining status, but simply because you qualify for something does not mean that if you have a threshold qualification does not mean that you can actually obtain that status. There are a lot of different ways that somebody cannot immigrate to the US. So I talk to a lot of people as well who will say, well, I'm married to US citizens, so that makes me a US citizen, right? No. It doesn't even mean that you qualify for a green card necessarily. If you were a child who was brought here, there's possibilities that you could have triggered immigration bars when you were a minor that you had nothing to do with, but that will either permanently or you know, impose a 10-year bar, what have you, on you in spite of the fact that you had no agency in triggering those immigration violations. So there's a whole other subset of immigration law that has to do with deportability and inadmissibility. I don't have a bunch of information on that for you today, but there's just suffice it to say that it's a very sticky swamp to make it through. I guess I could just say one thing. One example of that was we recently had a case where a young girl who was 16 years old and was coming to the U.S. Was put in a car with a smuggler who crossed the U.S. Border through the port of entry, and he claimed that she was a U.S. citizen. She was caught for that, and she was fingerprinted and processed and returned to Mexico. Later on, she married somebody with a green card. She had multiple children here. And when we sent her to the consulate, fully knowing that there could be issues, and she signed a waiver, she went to the U.S. consulate abroad. They held her responsible for that false claim, even though she didn't actually say the words herself and she was underage, which means she's now permanently inadmissible to the United States for the rest of her life because of something that occurred when she was 16 that she didn't even do herself. So it's an example of sort of the insanity. The other family-based categories are these. If you aren't either an immediate relative or in this in one of these categories, you don't qualify for immigration as a family-based matter. So brothers and sisters of U.S. citizens, adult married children of United States citizens, or spouses, minor children, and unmarried sons and daughters of lawful permanent residents. There's no category for married adults of lawful permanent residents. It's just a weird quirk of the law. And these are the wait lists. All countries in the world are distributed the same number of visas under our quota system. So if you're coming from, if you're coming from Switzerland, you're competing for the same number of visas as if you're coming from China. Because of that, the countries that are large generators of immigrants to the United States have individual backlogs. This all chargeability areas listed is what we call the worldwide category. And these numbers are for when you file the initial application. It sets your place in line. So, for example, if you filed your application in June of 2013 and you were from any country other than these four, then your category would be current, as we say, and you'd be able to apply. This C means that this category is current. So there's currently no wait list for spouses and minor children of lawful permanent residents. However, there is still really long processing times. So if you're moving through a consulate, a green card case through the consulate's minimally going to take 2 years at this point, and it could possibly take 3 or longer. And again, that doesn't address any other waivers or other grounds of inadmissibility that someone might have to overcome to be able to immigrate. Furthermore, the filing of the application and being in the wait list does not provide any lawful status or any means to remain in the United States. So you literally have to remain separated during that time. As you can see here, Mexico at this point has surpassed the Philippines in being the most severely backlogged country. And most of our categories, as they stand in 99, 96, they are between 20 to 25 years long. So employment-based immigration, in general, there's very little forgiveness for immigration violations. While there are additional waivers that are available in the family-based context, employment-based immigration requires almost incredibly precise adherence to maintaining status at all times, no violations whatsoever. They generally require a lot of planning. You have to have from one status to the next in order to have a seamless work authorization and ability to remain in the US. And in general, the employment-based requirements demand that either you're an amazing, extraordinary, top-notch person who is just so awesome that you will create concentric circles of awesome all around you, or you have to demonstrate that there are no US workers who are able, willing, available, and qualified to fill the position. So again, I think that especially as we move into the discussion of the proclamation and all of that, in the US of, supporting US workers, the system itself structurally is already built in such a way to force employers to pay for part of this, to pay a significant amount of money, to advertise for the position, to prove to the US government by a preponderance of the evidence that there's nobody else that they can hire. And it's not that they're employers are able to hire the person that they want the most or that they feel is the best qualified. If there is any US worker or worker with a green card already who meets the minimum requirements for the position, the US employer is not allowed to hire a foreign worker. That's what we call the PERM process, or the labor certification process. These are employment-based categories. In general, EB1 through EB3 are the primary ones that that we see in working. Religious workers, EB4 also has a number of other subcategories within it within that category. It's for special immigrants, and so religious workers are a number of those. There's also special immigrant juveniles and a number of other things that are within that quota. This is the employment-based immigration backlog as it currently stands. As you can see here, there are different countries that are broken out because the employment-based system works in a similar type of fashion. Part of the reason that you see the backlog in the fourth category here, both for the Northern Triangle countries as well as for Mexico, is because of the special immigrant juvenile quota. So special immigrant juveniles are lumped into the employment-based categories, which is a little strange, but they are children who are either abused, abandoned, or neglected and find themselves in the United States without one or both parents to be able to care for them. So a lot of the unaccompanied minors that we've seen especially over the past, I would say, decade, even in most recent years, have a large number of them have come from those Northern Triangle countries of El Salvador, Guatemala, and Honduras. And so there now is a backlog for those children. Apparently, our country only believes in accepting so many abandoned, abused, and neglected children, and they reluctantly do so as it is. There's been especially during the Trump administration, there's been a lot of struggle in front of the immigration court for these children that are in immigration proceedings, with some judges moving forward with their deportation in spite of the fact that they're stuck in this quota. You can see here as well that China and India are very significantly backlogged, in particular India, because of the high number of professional and amazing workers that come out of those countries. Up until just recently, actually even in the last month, the EB1 category was backlogged, kind of across the board. And it's really amazing because you could have won a Nobel Prize and have to be in a backlog. And that's still the case for extraordinary workers that are coming from China and India. There's more than a 3-year wait. So if you won a Nobel Prize and you're from India, you need to get in line before you're able to immigrate to the US. Likewise, people in the both EB2 and EB3 category are backlogged by really significantly for India as well, because they just simply generate a lot of amazing people. I'm just going to touch really quickly on the diversity program. which was also known as the lottery. It was established in 1990, and it's supposed to, create greater diversity because there's just a sort of random lottery, 50,000 immigrant visas available annually. They're drawn from random selection, and they're from countries that are not those high generators of immigrants to the US. It's kind of a strange program, but it still exists. I think I already mentioned the special immigrant juveniles. There's also a subsection of the law that includes self-petitioning against the violence against under the Violence Against Women Act. This is if within the family-based context. So if you're either a child, parent, or spouse, as is defined in family-based immigration, and the petitioner, United States citizen or lawful permanent resident, is abusive, battery or extreme cruelty, you may be able to fulfill the role of self-petitioning and not have to rely on that individual to move forward. There are greater forgivenesses for those bars that I mentioned before for inadmissibility or deportability for those who are immigrating under these means. So it is a more generous section of the law and does allow for some refuge for those so that you don't have to, quote, stay with your abuser or remain with somebody specifically because they're using immigration as another means of power and control in the relationship. There's also defenses to removal in immigration proceedings that may result in an LPR status as well. Okay. So, and some of you guys have gone through the discussion of asylum law that Jesse Miles and I presented a few weeks ago, but I'm just going to touch on the definition of asylum here, or the definition of refugee. It's defined in our Immigration and Nationality Act, but it did come out of that post-World War II society that we found ourselves in after people had been horribly tortured and harmed in multiple different ways. So this is how it's been codified into our statute. It's a really complex definition that has many, many moving parts. The primary difference between refugee and asylum seeker is that refugees are outside of the country and typically go through a process in the United Nations before being brought into the US. So a refugee is somebody who's already been determined to meet this definition prior to entry in the US. Whereas an asylum seeker is somebody who either is in the United States or presents at a port of entry in order to try and meet this definition. So I break out the definition because these are all different aspects of the definition that need to be proved in order to be successful with an asylum claim. Even this on account of is what we call nexus. And each one of these 5 enumerated grounds have their own body of case law and definitions, in particular the membership in a particular social group, which was created as a catch-all category in order those that set the basics of asylum law in our post-World War II world wanted to be able to anticipate the different ways that and the different reasons that people would want to harm each other moving forward. And so that was the catch-all category that could meet different people's circumstances in the future. It has been the one that has been the most beleaguered, and in particular, again, under the current administration, has been dismantled. What asylum is not, it's not for generalized civil strife, mere lawlessness and violence. And so a lot of times with clients, we'll discuss they say, I'm afraid of persecution, I'm afraid to return home, and all of that is true and valid and powerful for them. However, asylum is not meant as a generalized protection. It is meant as a specific protection for someone who's facing specific harm for specific reasons. So these are some of the ways that you can get denied for an asylum claim. One of the primary ways is the 1-year filing deadline. That does not exist in any other country that I know of. And it's kind of a bright line rule as far as, either you have to file within a year of arriving to the United States or meet one of two very narrow exceptions. If you file later, you have to demonstrate that it's your burden to demonstrate that you qualify for one of those exceptions. So it really does eliminate a lot of people's eligibility for that if they've been in the US. There's two different ways to apply for asylum. Principally, if you are facing a removal from the United States, you are doing what we call a defensive asylum case. So it's presented in court. There's the ICE attorney is the prosecutor in court. It's an adversarial system. Again, you have the statutory right to have counsel during that process, but no counsel will be provided for you free of charge. Unless you're lucky enough to find a nonprofit who's willing to provide that for you. The immigration judge and that whole system, of course, is within the Department of Justice. There's also the possibility of filing an affirmative asylum case through USCIS, but you automatically get referred into the defensive process if you are not successful with your affirmative case. U.S. law and international law guarantee a right to seek asylum whether or not someone arrives at a designated port of entry, which means regardless of your way of entering the U.S. Border entrant asylum seekers can present, at the port of entry or between a port of entry. And they're both subject to what we call expedited removal proceedings, which is the rapid fire removal proceedings that it can occur within the context of the Border Patrol. This entire system has been called into question under the Trump administration. And essentially this entire section of the statute has been rendered almost irrelevant because of the programs of metering and the migrant protection protocols, or the Remain in Mexico program as we call it. And it continues to be under serious dismantlement under the current administration. Okay, enforcement, dun 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 dun. There are three primary sectors of immigration enforcement: border enforcement, interior enforcement, and worksite enforcement. Then, of course, the agencies that handle them are slightly different. In general, the authority to detain is pursuant to the authority to arrest, which immigration officers have. Again, the detention is theoretically civil. Although most immigrant detention facilities are privately run by the prison industry. So they look like prisons. They feel like prisons. They essentially are prisons. Okay. So there is the possibility of immigration bond, but there are those who also are subject to what we call mandatory detention, where you are not eligible for bond, and that you must remain in detention while awaiting removal or defending your case. There are some outer constitutional limits on how long someone can be detained for. Oftentimes, immigration practitioners will have to pursue a habeas petition in order to get someone out of immigration detention if it's reached the outer edge of those detention times. But given the fact that the immigration system is so incredibly backlogged, it's not uncommon for someone to remain in detention for months, if not multiple years, if they're working at providing a defense to their removal. The pressures of detention often undermine any type of shred of due process that people in the immigration system face, because again, prison, limited ability for relief, and lack of access to counsel. As we know, there's a reason why immigration detention is the largest growth factor for those private prison industries. It's because there's practically no limit. You can detain men, women, and children in the various detention facilities. While children's detention has been the subject of ongoing litigation and debate, again, most of those, a lot of the protections have been actively pushed back by the current administration in order to allow for more extensive children's detention, as well as an erosion of the protections for them in those facilities. Okay, so this is actually the courtroom in El Paso. That's I've sat at that table a bunch of times. I know Jesse has as well. The proceedings, like I said in the beginning, are civil. Our court sits in El Paso. IJs are appointed through the Department of Justice. They are not true judges. They don't have contempt power, and they are not independent. The Immigration Judges Union has recently come out with some incredibly scathing pushback to everything they've been put through under the Trump administration. They have been required to meet quotas in order to get their, it's tied to pay. So they have to rock through cases as fast as they possibly can. And it's also because the immigration judges are appointed through a straight line directly from the Attorney General. Essentially, they have puppet strings that are tied to the executive branch. So the way that the system is set up is that, if there's successive policies that are set by the executive branch, it flows directly down to and can influence the immigration judges to act or enforce the law in a particular way, even though they are technically supposed to be adjudicators. It definitely feels like when you're presenting a case in an immigration court that it's 2 against 1, and that the judge a lot of times is in a prosecuting position. I am probably influenced in my perspective of that because my primary court is El Paso, which has come under a lot of critique and scrutiny because of the difficulty in winning cases there and the overall culture of prosecution. It also is a difficult thing for respondents, as we call them, in removal proceedings anywhere in New Mexico because they are generally forced to travel to El Paso or process through that court system. It also means that even if somebody's living in New Mexico and technically is part of the 10th Circuit, that if any appeal that's coming out of the El Paso court, and when you're in court, it's under the jurisdiction of the 5th Circuit, which of course is, especially within immigration, can oftentimes be more conservative and more strict. There's no rules of evidence in immigration court proceedings, which makes it pretty loosey-goosey. And really subject to, again, the whims of whatever immigration judge is proceeding over the proceedings. There's very limited judicial review. There is the ability to appeal most immigration judges' decisions through the Board of Immigration Appeals. However, that is, again, also the Board of Immigration Appeals, and all of the decisions are directly under the Attorney General. Defenses usually involve a way to stay in the US, and if somebody does not present themselves to proceedings, as long as they've received very minimal, shallow notice, they can be deported in absentia. There's a wonderful resource called the TRACK system out of the University of Syracuse that tracks all types of statistics for immigration court and immigration proceedings and asylum. If you have not visited that website, I would highly recommend that you do. You can completely geek out on all kinds of information. It's wonderful. It currently tracks the immigration court backlog at being we're just about to hit the 1.2 million foreign nationals that are in immigration proceedings. There are about 460 judges that are proceeding over those 1.2 million people, and they are in about 67 courts across the country. Again, math, not my super strong point, but looks pretty impossible from those numbers when you put them together, as it definitely feels like it is when you're in court. Cases drag on for multiple years, especially for those who are not detained. It's an extraordinary long process. Okay, on that wonderful note, I'm going to go ahead and talk about citizenship. Somebody just dropped a package off at my house, so there's probably going to be pandemonium. So 3 ways to become a United States citizen. There's naturalization, where you actually apply to become a US citizen. There's a possibility of deriving citizenship through the naturalization of parents. And then there's also the ability, by soil or blood, through birth in the US, birthright citizenship as we call it, or to one or both U.S. citizens abroad. In general, you have to be admitted as having your green card before you can, obtain U.S. citizenship. So a lot of times, you'll hear in the news or in the media that, that they need to obtain their citizenship. And that's, of course, one of those many occasions that I yell at my radio, because it's not straight to citizenship for most people unless they either drive or acquire. Most people have to process through the green card process and qualify for it and make it through that labyrinth and all of the difficulties before they can even approach naturalization. You also have to show good moral character for 3 or 5 years. You have to speak English or qualify for one of the exceptions. If you had a green card for over 15 years and you're over 55 years of age, you can do it in your own language. You still have to pass the test of history and government. There are many different ways to have issues with good moral character. And and if you qualify for the 2065 exception, over 20 years of lawful permanent residency and 65 years of age, you get to take a simplified test. There are some waivers that are available for people who have some type of medical or emotional circumstance that doesn't allow them to learn English. So I've done it for people with dementia or with severe delays of different types. I've done it for people with severe PTSD, but they're incredibly difficult to obtain, and USCIS in general does not like to approve those. So, I mean, even with individuals who have progressive dementia, we've really had, you have to kind of do a paint by numbers for them and explain exactly why the condition prevents learning in order to be successful with that waiver. So these are, again, the 2 different ways of automatically acquiring citizenship. Sometimes when somebody has their green card and one or both of their parents naturalized, especially after 2001, they automatically become a U.S. citizen by act of law. And those are really fun people to find. Sometimes they don't know that has occurred, and they think that they still have their green card when really they are a United States citizen. Oftentimes that will come up in the context of they're facing deportation, or they've been charged with a crime or have an ICE hold or something like that. And it's a pretty wonderful thing to be able to discover for somebody when they don't know or they were unsure. All right. Whirlwind tour as we are doing. So now onto the some of the major recent changes that we've seen. This is not an exhaustive list by any stretch of the imagination. Like, it's really overwhelming sometimes trying to figure out everything that has happened. Even within the attorney groups that I'm part of, professional organizations, as well as Facebook groups, informal stuff, we're constantly like, did I miss something? What happened now? What's going on? Because there's just so much happening. It really does feel like your face is in the fire hose. It's intense, and it's difficult to keep up with your professional responsibility of competence when it's like whiplash all the time of whatever's happening. As we know, Trump was elected, on a platform that included anti-immigrant rhetoric, as well as, a policy of enforcing immigration to the top degree. And I think that what we've seen is a real erosion of even the statutory rights that are allowed for immigrants, which were limited to begin with. So one of the major issues that we've seen during the Trump administration is the use of AG certification. So there are a number of, I was trying to find them, wasn't able to do so right before this presentation, but the Attorney General currently has a number of cases under certification right now. Because of the way that immigration works, it's administrative law, and like I said, the decisions by immigration judges are appealed to the Board of Immigration Appeals. But given the fact that the Attorney General is in charge of the Board of Immigration Appeals, he has the sole authority to reach into the case law and the jurisprudence as established by the Board of Immigration Appeals and single-handedly change the course of case law. So that has been done more by the current, I would say more profoundly, to not only It was used by the Bush administration 16 times. We're rapidly approaching more than that under the Trump administration, and they have significantly changed the course of immigration law, including practically eliminating our ability to ask for a continuance in removal proceedings, undermining the definitions of family-based asylum, as well as domestic violence claims, gang-related claims, really changed the definition of asylum to narrow it as significantly as possible. So the litany, 2017, we've seen, of course, we saw 3 different versions of the travel ban or the Muslim ban. The Buy American, Hire American executive order, limited, again, was primarily going after employment-based immigration. The end of DACA, of course, was announced at that point, even though it was enjoined for renewal applications for a period of time after that. And then the number of refugee admissions was severely limited within that first year. Also, by the end of 2017, we saw significant steps taken to end TPS, which is temporary protected status, which are supposed to protect those who've had the undocumented in the United States whose countries have suffered either some type of civil strife or major ecological disaster like Haiti with the earthquake. Trump did announce the ending of TPS for Haitians and then also for Salvadorans. In January of 2018, USCIS started processing the most recent asylum applications most quickly, so that even though there was a backlog of asylum applications that had been pending often for many years, these affirmative applications, they started immediately setting up the most recent applicants for interview as a matter of trying to dissuade people from applying. One of the applications that I submitted was scheduled for interview in 2 weeks. So you really have to have it together and be ready to move forward with your case. The idea was that they would be able to deny people because they weren't prepared to proceed. May 2018 was when the metering began at the border, where people were forced to be put into a waiting list. They weren't allowed into the United States if they wanted to apply for asylum. Of course, in 2018, as you all probably remember, that began the prosecution of parents with children at the border, so the family separation policy that ultimately was rescinded. In 2018, we had what's called the NTA or RFE memo, which basically said that if you're applying for any benefit in the country and you don't have some type of underlying status, that if you are unsuccessful with a case or if your case is not properly filed, that you can be immediately sent into immigration court proceedings. So this really affects people who are doing their own applications. Also, if the application was incomplete in any type of way, that they could simply deny the case outright and put you in proceedings instead of doing a request for evidence in order to complete that. Some of the other things as well. 2019 was when we saw the beginning of the MPP return to Mexico policy, which basically stopped all asylum along our border and has created refugee camps along our US-Mexico border. The third country transit ban and the asylum cooperative agreements was to force asylum seekers to not even reach the US or to deny them on the fact that they passed through another country, which may be generating asylum seekers in and of itself, but force them to return to those countries to apply for asylum instead of in the US. Of course, now things have been shut down because of COVID. The immigration courts are still closed. They're slowly, sporadically reopening for non-detained courts. The detained courts were still moving forward. USCIS has just started to reopen. And of course, Otero, the facility in the southern part of New Mexico I heard some reports that there's an 80% positivity rate for those who are detained there. So, but there has not been a large amount of a large move to be able to release those people. The presidential proclamation on limiting immigration, it was first put into place on April 22nd, and then the second version, the extension, came out just this week. Has it really only been this week? Yeah, so it suspended all H-1B visas, H-2Bs, which is for seasonal workers, J-1s, which include physicians, exchange workers, professors, au pairs, and some other limited workers, as well as intercompany transferees. Now, this is supposed to protect US workers. However, when you really take a good look at these categories, the H-1Bs coming into the country from outside the US, again, there's already a limited quota. The H-2Bs, you actually have to do a testing of the labor market to show that there's a seasonal need. You can think like Vail or you know, places like that where there's a high seasonal need based on that. H-2Bs are used for like landscapers and that sort of thing. You already have tested the labor market to show that there's not US workers available. J-1s also, because they are international exchange, they do not impact the US workforce in the same type of way. And foreign trade medical professionals, of course, coming under that category, it's pretty crazy to put the brakes on that given the current circumstance. It also eliminates all of those preference categories. So individuals who had been waiting in those lists for all those years are now not able to process either. It's basically stopped most immigration through the US from abroad. Of course, the consulates are still closed, so it's not entirely clear, you know, what will happen once the consulates reopen, but it is a really significant step in trying to basically undo the entire statute that has to do with immigration. Also, parents of United States citizens are included in that proclamation as well. I think I'm out of time, but you can just see here, this is the denial rates for asylum cases have gone up significantly throughout these years. Because that, of course, has been the intent, is to eliminate asylum, and the number of refugees has dropped down to practically none. All right. On that note, let's see where we're at here. I feel like I've been talking like crazy. So I'm not sure, April or anybody else, if you have any like follow-up questions.
Now, we just want to really thank you. That was awesome, Jesse. I mean, awesome, Becca or Professor Kitson, excuse me. We really appreciate you getting us started with this. And Anne has just put the email in the chat where people can follow up. Sue George has also put in the chat where you'll need to send your CLE forms. We hope that you'll contact us if you would like to volunteer or find out more. And again, we'd like to also thank the Leifer Foundation for inspiring and their generous funding for this Border Justice Initiative. So thank you, everybody. And if you would like to follow up, please see the chat for the email or track down one of us.